Article 21. This article concerning the right to life and personal liberty has a wide scope and encompasses all aspects of a person's existence that make it more meaningful. Article 12 of the Universal Declaration of Human Rights Act, 1948, reads in part, "No one shall be subjected to arbitrary interference with his privacy, family, home, or communications, nor to attack against his honor and reputation," thus recognizing the right to privacy as a fundamental human right. In India, the Supreme Court proclaimed the right to privacy to be a fundamental right in the case Puttaswamy v. Union of India case in 2017. The petitioners contend that the right to privacy includes the freedom to decide on sensitive and private issues, like undergoing medical procedures to extend one's natural life. This means that individuals must be given the freedom to choose whether they want to continue their medicated life or end their sufferings. Right to die with dignity. It is widely accepted that the right to life guaranteed by Article 21 extends beyond simple survival. In the Jian Kaur v. the State of Punjab, 1996 ruling, the right to die with dignity was established as a fundamental right, and the Constitutional Court's 5-judge panel, which included the then Chief Justice of India Deepak Misra, Arjan Kumar Sikri, Ajay Manikrao Kanwilkar, Dr. Dhananjaya Yeshwant Chandrachud, and Ashok Bhushan, decided that both voluntary and involuntary passive euthanasia are acceptable. The court declared, "The right to live with dignity also incorporates the facilitation of the dying process for those who are terminally ill or who are in a passive vegetative state and have no chance of recovery. The right to a dignified death and to a smooth end to life may not be supported if advanced medical directives are not legally recognized." According to the petitioners, a person's right to dignity lasts till the end of their natural life. A life which is unnecessarily stretched with the help of life support or other medical equipment without their approval does not accord them dignity when their natural life has begun to wane due to old age or a fatal illness. Considering the precedents of the Apex Court, the right to life does not include the right to death. The petitioners contend that even while the right to death is not part of the right to life, it must be a part of the right to a life with dignity, right to freely practice one's profession. The petitioners also make a reasonable argument that doctors are obligated to continue treating patients, even when they are aware that doing so will only cause them pain. Their right to freely practice their profession is being violated by this. Additionally, they point out that when scarce medical resources are used to extend the natural lives of individuals who are unable to recover, others who could benefit from the same resources are excluded. This is a violation of their right to life under Article 21. Right to liberty. Article 21 imposes on the state the duty to preserve life and liberty, in addition to upholding the individual's right to life and liberty. The petitioners contend that in order for the state to uphold its duty to safeguard life, it cannot compel anyone to receive medical care against their will. This is because everyone has the right to live life with liberty. They contend that if a person merely remains physically alive, but is mentally or emotionally incapacitated, they should have the option to decline life-extending medical procedures. The right to liberty under Article 21 is violated when this option is denied. Background. The question of whether the freedom to die is a fundamental right guaranteed under Article 21 was first put before the Supreme Court in Pirathonam v. Union of India, 1994. In this case, Section 309 of the Indian Penal Code 1860E, attempting to commit suicide, was challenged on the ground of being against fundamental rights. Invoking the ruling in Maruti Shripati Dubalvar, the state of Maharashtra, 1987, the court determined that Section 309 of the Indian Penal Code was unconstitutional because fundamental rights can have both constructive as well as detrimental aspects. It stated that the right to life would also include the right to die later. In Jian Kaur v. the state of Punjab, a constitutional issue regarding Section 306 of the Indian Penal Code, 1860, which deals with abetment to suicide, was brought up before the Apex Court. Here it was contended, quoting P. Rathanam v. Union of India, that aiding in the suicide of another person could not be punished because the aiding party was only assisting in the execution of a basic right. The court overturned its decision in P. Prathanam stated that because all basic rights differ from one another, a single test should not be adapted to them all. Since there is a negative component to the safeguards under Article 19, Article 21 cannot be interpreted in a comparable way. Furthermore, suicide cannot,